If your employer has informed you that you're not meeting the expectations of your role and your job is at risk, you may be wondering whether your employer can terminate your employment for performance-related reasons. Hi, I'm Mike from Cash and Legal, and in this video, I'm going to discuss an employer's ability to terminate employment for cause due to poor performance in the workplace. At the end of this video, you'll have a better understanding about when an employer can terminate your employment for cause due to performance-related reasons and when they cannot do this. I'll also provide you with some guidance on how to respond if you find yourself in a situation where your employer is threatening your employment due to a performance concern. At the very outset, I want to create a clear distinction between for-cause terminations and without-cause terminations. A for-cause termination means an employer terminates your employment and does not provide you with any severance, whereas in a without-cause termination, an employer provides you with either notice of termination or pay in lieu of notice. If your employer is terminating your employment for cause, there is a very high bar that they need to meet in order to justify this. On the flip side, if your employer is terminating your employment without cause, they actually generally don't even need a reason to do so. Your employer often doesn't need to justify the assessment of your performance and can simply say this person is not a right fit for the organization and let that person go. Because your employer is providing you either with notice or pay in lieu of notice in this situation, they are not required to justify the basis for your termination. Where the situation is less clear is if your employer is attempting to terminate your employment for cause due to a performance-related concern. If your employer is attempting to terminate your employment for cause due to performance reasons, there is a very high bar that they need to meet. Generally speaking, workplace performance concerns don't justify termination for cause unless they rise to the level of incompetence. Incompetence doesn't refer to regular performance concerns, making mistakes, or even failing to achieve targets or quotas. Incompetence refers to a serious and ongoing inability to perform the essential functions of your role. In order to prove incompetence, employers have to meet a very high bar. Generally speaking, there are 4 things that the law looks for in order to establish incompetence. Firstly, the performance assessment must be done on objective, reasonable standards. This means it can't simply be a fit issue or some other concern that isn't objective but dealing with the subjective assessment of someone's performance. There must be a clear standard that the employee is failing to meet in these circumstances. Secondly, the employer must prove that the employee actually failed to meet those standards. There has to be some amount of objective, tangible evidence that demonstrates the employee didn't meet the standards that were communicated to them. Thirdly, in most cases, the employee must be warned that they are not meeting the standards and that they need to improve and meet those standards in the future. In this scenario, the employer must demonstrate that the employee was told what they were doing wrong, that they needed to improve, and that there would be serious consequences, including termination of employment, if they did not improve. The courts generally say that the warning must be clear enough that the employee understands their job is at risk. Finally, following the warning, the employee must be given a genuine opportunity to improve. If an employer provides a warning related to a workplace performance issue but doesn't give the employee the opportunity to improve, the employer likely cannot terminate that employee's employment for cause. This means that once the warning is issued, the employer generally has to wait a reasonable period of time and provide the employee with adequate support in order to address the performance-related issue. In most circumstances, if these 4 things are not present, the employer generally cannot establish incompetence that would justify termination for cause. Another thing the courts will look at in order to determine whether the employer has met this high bar is the level of training the employee received. If the employee has received inadequate training from the employer in respect of this performance-related issue, that might eliminate the employer's ability to terminate that employee's employment for cause. This is particularly relevant in the context of an employee who's either moved to a new position or provided with new responsibilities, but the employer doesn't provide sufficient support to allow the employee to learn how to do those new jobs. Another important consideration in this set of circumstances is the duration of your employment with your employer. Generally speaking, long-term employees are afforded more leeway in the performance assessment process by the courts. In these circumstances, this will only heighten the employer's requirement to provide clear warnings and provide the employee with opportunities to improve. Another important consideration in this scenario is consistent messaging. If the employee can demonstrate that they reasonably believe that their job was not at risk because of some communications that the employer made, this significantly reduces the employer's ability to terminate for cause. For that reason, it can be helpful to go through the employee's performance reviews in order to ensure whether the messaging to the employee was consistent in the circumstances. One final consideration in this scenario is whether the employee's performance issues are related to a genuine health concern. If the employee's performance is related to a genuine health issue and the employer knew or ought to have known of that health issue, that can impact the employer's ability to terminate for cause. Any employee who's experiencing a health issue that affects their ability to carry out their role may receive protection under Alberta's human rights legislation, and in that scenario, the employer generally cannot terminate employment. In this situation, the employer has a responsibility to accommodate the employee up to the point of undue hardship, which means working with the employee to address their health concerns and determining whether they can continue to contribute to the workplace. If the employer fails to fulfill this duty and simply terminates employment, this may be a breach of the Alberta Human Rights Act. One question we often get from employees in this scenario is whether one single mistake can justify termination for cause. In most circumstances, one single mistake doesn't justify termination for cause, but there are situations where it does. If the employer can prove that the employee's mistake was due to their failure to meet a standard that was clearly communicated to them and was an essential component of their role, this single mistake may justify termination for cause. This is particularly true where the risk to the employer is significant. For example, if the mistake involves a serious safety issue or poses a significant financial risk to the employer, that would support their ability to rely on this single incident to terminate their employment for cause. So with all that being said, what should you do if your employer has indicated they might terminate your employment due to performance-related reasons? First and foremost, I want to stress that it's never too early to seek legal advice in these situations. If you would like to have the assistance of a lawyer during this process, do not hesitate to click the link to our website in the description of this video. Apart from seeking legal advice, the first step is to always clearly understand what the performance-related concerns are. This means asking your employer to communicate in writing what the performance-related issues are so that you clearly understand what objective standard you are not meeting. The second thing you should always do is communicate your own position in respect of these objective standards. If you feel like these standards are unreasonable or beyond the scope of your role, this should be communicated to your employer clearly and in writing. As always, it's important to stress that communications with your employer should be professional and courteous. While you may not be happy with the circumstances you're dealing with, you should still be mindful of the way that you're communicating with your employer. Thirdly, if you and your employer are unable to agree on an objective set of standards that you need to meet moving forward, it's probably a good time to seek legal advice. If your employer has communicated performance-related concerns and you don't know what to do, we can assist you with this. We help employees in this situation by providing them with clarity about their situation, strategies for responding, and peace of mind through sound advice and strong representation. If you need help with this situation, do not hesitate to click the link to our website in the description of this video and book a consultation with our office.